Do each of you have a proposed packet in front of you?
Yes, Your Honor.
Yes, Your Honor, and this is from the email that Ms. Frablin sent yesterday. But I have it open to make any edits.
Great, let's take a look at it. Introduction to final instructions. We'll go page by page. Any objection to this by either side?
No objection, Your Honor.
No, Your Honor.
3.2, now let me just remind, just so Mr. Tower understands. We're having this jury instruction, we call it a charge conference. We're having this early because time allows us to have this discussion. This doesn't mean these are permanent. There could be changes that happen based on the additional evidence presented. For example, once the state closes their case in chief, your attorney will make arguments. So we haven't had motions yet. So this is an early look at jury instructions, Mr. Tower. This isn't a final discussion. We'll have another discussion once we've closed all the evidence before we were to read this to the jurors, okay?
Your Honor, just a question. Do you prefer like page numbers?
No, I don't need page numbers. Does the defense have any preference? My preference would be not to do page numbers.
I would not like them either.
Okay.
All right, next is statement of charges. Again, in this case, we had the defendant was indicted on 2 counts of first-degree murder. I granted the state's motion to consolidate those 2 counts with the fleeing to elude. Because he was indicted with first-degree murder, the second-degree murder charges that were initially filed were declined. I think there was a written order to that effect, not order, but motion by this memo by the state. Is that right, Emily? Did Ms. Frabley bring something over to you on Wednesday on the second-degree murder charges?
Yes, but I believe there needs to be further clarification.
Further clarification, okay. So these...
Oh, wait, it was clarified, yes.
It was clarified. All right, so these appear to me to be the statement of the charges that the court allowed to go forward on. Count 1 is murder in the first degree. The state identified Mr. Gilman to make 1 and 2 unique. They put in the alleged victim.
Yes, Your Honor.
I think that's appropriate. Do you have any objection to that?
I do not.
And then count 3 is fleeing to elude. They also inserted here to identify it siren and lights activated. Again, we'll get to that later, but they're lesser included. So I think that's appropriate. Any objection to the statement of charges page?
No, Your Honor.
All right, next we have 7.1, introduction to homicide. Unless expressly waived by both parties, this must be read in all homicide cases. I've reviewed it. The state just inserted the correct pronouns. They do have, Mr. Gilman, both lesser included counts of murder in the second degree and manslaughter inserted. And they have the defendant's name, Dima Tower, inserted as well. It appears to me, as I went through it and compared it to our Supreme Court version, that it's legally accurate. Do either side have any objection?
No, Your Honor.
No.
All right, next we have 7.2. This is the instruction on murder first degree. It has the statute number. I have compared this to the Supreme Court version. It appears to be legally accurate. It has the defendant's and the defendant and alleged victim's names. Now, they're all capitalized. The state has been consistent throughout doing that. Is there any objection by either side to that, to capitalizing the names?
I
think it's usually done. I can't think of any prejudice to capitalizing
No.
a name. It's not in any way.
I don't think I have any objection to it, Your Honor.
I know from the state.
All right, any objection to this instruction as it relates? So this is count 1. This is with Jennifer Tower as the alleged victim.
No objection, Your Honor.
No objection.
All right, count 2. It's the same exact instruction, except if you look at element 1 and 3, instead of Jennifer Tower, it now has Robbie Tower, which is consistent with the state's indictment that Robbie Tower is the victim, alleged victim in count 2. Any objection to this instruction?
No, Your Honor.
Next is 28.7. Again, I did already compare these to our Supreme Court version. I found no mistake in this either. Names are capitalized. The defendant's name is inserted. There's no victim name here. It has the definitions. It has the 3 elements correctly outlined. Any objection to this by either side?
No, Your Honor. The only issue is there is I don't know if you want to take the brackets out of the vehicle definition.
I definitely think we should. I
Yeah.
missed that. Yeah.
I'll-
Thank you for catching that.
Yes, Your Honor.
All right, let's address the lesser included crimes to count 1. They are murder in the 2nd degree and manslaughter. Are either side requesting those?
Yes, Your Honor.
Okay. Yeah, I think it's appropriate to include these. The state appropriately did here. So we have murder in the 2nd degree and manslaughter. For fleeing to elude, the 2 lesser includeds in the definition are fleeing to elude without sirens and lights and reckless driving. Are either side requesting either of those?
No, Your Honor.
State?
So defense is not requesting any lesser included for
The fleeing to elude?
the fleeing to elude?
Correct.
Okay. We'll request the first, the felony fleeing to elude.
Okay. So you want to make the argument that there were no lights and sirens activated. Okay, let's keep in fleeing to elude without lights and sirens. Both sides agree not to have reckless driving. State defense?
Correct, Your Honor.
Okay, we'll remove reckless driving. All right, so we now have the definition. So we're now going to get into the lesser includeds. The state did one, which is probably appropriate for each count 1 and count 2. So the first one is murder 2nd degree. They inserted victim Jennifer Tower. So this is the lesser included for count 1. I compared it to the standard instruction. It's legally accurate. The portion that's in the standard instruction that the state has not included is the whole discussion on negligence. Do both sides agree that does not apply?
Yes, Your Honor.
Yes.
Yeah, I agree as well. Any objection to this instruction?
No, Your Honor.
Yeah, I think it's legally accurate. Again, I compared it to the Supreme Court version, and it is the same. All right, next we're still on count 1 now. The lesser included crime is manslaughter. They inserted victim Jennifer Tower again. It shows to the jury that this is still count 1. It has the 2 elements. Again, I compared this to the book. It is accurate. Any objection by either side?
No, Your Honor.
All right, we're now moving to count 2. This says victim Robbie Tower. Count 2, 2 first-degree murder is 2nd-degree murder. It's the same instruction as the lesser included is to count 1, although instead of Jennifer Tower, we have Robbie Tower inserted. Any objection by either side to this?
No, Your Honor.
State?
No.
Okay, we also have the manslaughter instruction for count 2. This is the victim Robbie Tower. They inserted the defendant's name, victim's name. Otherwise, it's the same instruction. Any objection?
No, Your Honor.
All right, we have the lesser included for fleeing to elude, which is fleeing to elude. Any objection? Oh, we need to do what Mr. Gilman pointed out before. You still have the bracketed part in the vehicle definition. Can you remove that?
Yes.
Once that's done, any objection to this instruction?
No, Your Honor.
All right, reckless driving will be removed. Good morning, Ms. Fravelig.
Good morning, Your Honor.
All right, next in my packet is 3.7, plea of not guilty, reasonable doubt, and burden of proof. This appears to be the old version. We need to get the updated version, 2025. The only difference is that in the paragraph that begins, a reasonable doubt is not a mere possible doubt. That paragraph has changed, and that paragraph now begins, proof beyond a reasonable doubt does not mean proof beyond all doubt. Are you able to get the updated version?
Yes, Your Honor.
Other than that, it's the same. All right, once that change is made, is there any objection by either side?
No, Your Honor.
Okay, I'll give you a moment, Ms. Whipple. Let me know when you've finished that.
All right.
Okay. Next, I have 3.9, weighing the evidence. Okay, we have 1 through 5 that are given in all cases. So what we don't have is 6 through 10. So let me just read them out loud and let's see if we think so far any apply or if you can anticipate perhaps. Number 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify?
I would not think that applies.
State?
Agrees.
All right. Did you say agrees?
Agrees, yes.
Okay.
I
All right, so right now we think 6 does not apply. 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony?
I do not anticipate that testimony either.
No, it doesn't apply, Your Honor.
Okay. 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? I don't think we've had impeachment so far. We'll see how it plays out. I think we have, we'll see how the rest of the trial plays out. But so far we agree it wouldn't apply.
Correct.
All right. 9, has the witness been convicted of a felony or a crime of dishonesty? There's been none of that so far. We'll see if that changes for the remainder of the trial. 10, does the witness have a general reputation for dishonesty or truthfulness? There's been no testimony related to that. So far I would agree that 6 through 10 don't apply. We'll have to readdress this at the end of the evidence. All right. Whether the state has met its burden remains in. The fact that a witness is employed in law enforcement, we give in all cases. Expert witnesses can remain in. We didn't have any accomplice or informant, so that was correctly not included. There's been no child witness. We'll wait to see if Mr. Tower testifies, whether or not to include that or exclude it. Proper for a witness to talk to the lawyers and relying upon your own testimony. So this appears to me to be legally accurate right now. The only issue is when we find whether or not Mr. Tower testifies, we'll address that. The next one, 3.9a, defendant not testifying. We'll wait to see what Mr. Tower chooses to do. 3.9b, defendant's statements. We have that here. We have a statement that was played to the jury yesterday. This is something the jury should take into consideration, this instruction. I've compared it to the Supreme Court version. This appears to me to be legally accurate. Any objection by either side?
No, Your Honor.
No.
3.10, rules for deliberation. All of them are included except the jurors talking about questions they asked. Of course, they didn't in this trial. So this appears to me to be legally accurate. Any objection by either side?
No, Your Honor.
No, Your Honor.
Cautionary instruction is legally accurate. I will read that, of course. 3.12a, we have single defendant, multiple counts. Can you get rid of and informations in the title portion there?
I just called it charging documents.
Can we just get rid of it?
Yeah.
I think single defendant, multiple counts is the issue that the jury, we're honing them in on here.
Thank you.
So let's see, you have a separate crime is charged in each count of the charging. Can you make that singular document? I granted a motion to consolidate, so we don't need them to be thinking that we have an information and an indictment. I think that's irrelevant.
Yes, Your Honor.
But we do need them to know that there's multiple counts and they need to consider them separately. So let's see. A separate crime is charged in each count of the charging document. You're getting rid of the S. And although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. This now appears to be legally accurate to me. Any objection once we remove and informations and the S in documents?
No, Your Honor.
Okay.
No, Your Honor.
Ms. Whipple, were you able to make those changes?
Yes,
All right, the verdict instruction 3.12 seems appropriate. Any objection?
No objection.
All right, verdict. looks good to me as well that the state listed, I think, appropriately consistent with the jury instructions. They listed the alleged victim to identify the difference between count 1 and 2. They have the lesser included. It's perfectly lined up. There's nothing italicized or drawing attention to any one in particular. Guilty and not guilty are not capitalized throughout.
Count 3.
Your Honor, I did, for count 3, that this isn't my intersection. Initially, there wasn't the lesser included, but can I talk with Ms. Frayling for a second?
Sure, about whether you want the reckless or...
There's something that has to be changed about the title. It's called fleeing to elude. I have attempting, and that has to be removed. Defendant is guilty of fleeing to elude a law. Or what happened? Did we?
So, earlier when we were going through potential lessers,
Yeah.
Mr. Gilman said that he was not requesting the lesser fleeing or the reckless driving.
Okay. Okay,
Because
great.
I had said initially maybe the lesser included of the fleeing to it, or do you want, no lessers at all?
No lessers.
No lessers?
Yeah.
Okay, so then.
All right. So what we're going to do, though, Your Honor, is take away B and C.
Well, there's currently only B.
I might have a different version, but so right now I have A, B, D. So
Right.
A would be the defendant is guilty of, let's see, how do you have it labeled on you? It'll be the defendant is guilty of fleeing to elude law enforcement officer, parentheses, sirens and lights activated. So it's consistent, I think.
Yes. And
As
then-
charged. And then B would be the defendant is not guilty.
Yes, we just consulted and the state is no longer requesting a lesser.
Right, I heard you.
Okay.
Yeah, I think yeah.
Or attempting.
Mr. Gilman, did you hear that?
I did.
Okay, so it's going to be A, B. And you're just going to include lights and sirens, although just to be consistent. And then it has the correct month, year, place to be signed. It looks legally accurate. All right, let's discuss this now. They have your last page, submitting case to jury. Talking about what evidence would go back. Can you get both, Emily, can you pull out both knives for me? The ones that are not the butcher block. I don't want the butcher block. So my thought, folks, on evidence that can and cannot go back to the jurors. My thought is the butcher block with knives loose should not go back to the jury. That's too much of a danger. I could tell them that if they want to see that, they could just send a note. We can bring them into the courtroom, and we could have that shown to them. The question is on these two items, whether they're secure and safe to go back to the jurors. What are your thoughts?
Yeah, I take a quick look.
Yeah, come on up. And Carl, you can express your concerns and thoughts. I think the bailiffs are hesitant to allow those to go back.
This is very easily can come out of this with no problem. Yeah.
Not only that, Your Honor, there is biohazard on there, so we can tell the members of the jury.
Oh, that's true. There's alleged blood on
that
there, right?
It's not going back because of biohazard, but if they wish to see it, they can view it in front of all of us with the bailiff showing them again. They're all photographs of this evidence, so.
Mr. Gilman, what's your position? Are you okay with that?
I'm fine with that, Your Honor.
You are?
Yeah, and again, there's photographs of everything.
Okay.
So if it's a safety concern, I have no problem with them just having the photographs.
And the state's okay with that?
Yes.
Okay. That's what we'll do.
So no butcher block, no knives.
What I'll do is I'll explain to them. So let's see. Let's look at our jury instruction. During the trial, towards the bottom, folks. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. A, and here's the options for us. A, some of these exhibits will be sent into the jury room with you when you begin to deliberate. And B, if you wish to see any other exhibits, please request that in writing.
I think both of those would be
They
appropriate.
apply. So let's just keep it the way it is. And I'll explain to them the only items that are not going back to the knives. And I'll explain that to them, that they just need to put that in a note, and we could bring them in here for them to see it, okay? All right, so 3.13, submitting case to jury. It's fine, the instruction as it is. I have the closing argument instruction. You don't need to give that to the, you don't need to include that in the packet that goes to the jurors.
We'll take it in.
Are there any other instructions either side are requesting?
No, Your Honor.
No, Your Honor.
And I can't think of any other instructions that apply as well. All right, so State, if you can make those changes, if you can send a copy to me and Mr. Gilman so we can have at least our updated version. We'll address it again at the close of the evidence. It's 9:22. We'll be adjourned. If you can be ready to start the trial at 11.
Yes, one thought, Your Honor. Do we want to discuss now, there is a DVD of the defendant's interview. The jury may wish to listen to that, or also the 911 calls. Did we want to talk about...
That all goes back to the jury. I mean,
Right,
to the,
but do they, are you going to explain to them how they can play it and do that sort of thing?
what I do is I bring IT in to just explain the jury card. I like to have that on the record, that the jury card doesn't do anything. It doesn't have access to the internet. All it can do is play the evidence. So I'll bring in Kevin or Henry, someone from IT. They'll wheel it in. They'll explain to them how it works, which is basically just a mouse, and all they can do is stop, pause, fast forward. And then I'll have Henry wheel it into the jury room.
Thank you.
Okay?
Yes, Your Honor.
Good.
All right, have a nice break. Let's be ready to start the trial at 11 o'clock, okay? All right.
Well,